Um, I'll deliver the opening remarks. Thank you, Chair, for the opportunity to be here today to speak to former Bill C-36, as well as what we know about the social context to which it applies and its impact. Available data in Canada and around the world identifies that the majority of people who provide sexual services are women and girls. The vast majority of those who purchase sexual services are men, and the majority of profiteers and procurers are also men. Unfortunately, there's limited data on the involvement of LGBTQ2 individuals. The 2006 report of the Justice Committee's Subcommittee on Solicitation Laws indicated that about 75 to 80% of persons engaged in the sex trade are female, and about 20% are men or gender diverse individuals. More recent data from research undertaken by Dr. Benoit of the University of Victoria and Dr. Bruckert of the University of Ottawa are consistent with what the subcommittee reported in 2006. The reasons why people may provide sexual services are diverse, and their involvement in the sex trade is influenced by a variety of socioeconomic factors, including poverty, youth, and lack of education. While some involved in the sex trade are independent in the sense that they're sufficiently empowered to control how, when, and where they provide sexual services, many others are not. In response to the Supreme Court of Canada's 2013 Bedford decision, Parliament enacted former Bill C-36, which came into force on December 6, 2014. This bill brought into force a version of the Nordic model, first implemented in Sweden in 1999. Former Bill C-36's preamble identified its objectives as including protecting human dignity and equality and preventing exploitation and violence. Consistent with other Nordic approaches, the bill sought to achieve these goals by targeting the demand for sexual services and those who capitalize on that demand. Specifically, the bill created new offenses prohibiting purchasing and advertising sexual services, as well as receiving a material benefit from others' sexual services and procuring others to provide sexual services. The bill also immunizes those who provide sexual services from criminal liability for the role they play in the now illegal transaction for sexual services. These offenses also continue to criminalize purchasing sexual services from minors and involving minors in the sex trade. The parliamentary record indicates that the exceptions to the profiting offense, the material benefit offense, are intended to ensure that those who provide sexual services aren't prevented from hiring bodyguards and others who may enhance safety. And the immunities are intended to ensure that individuals are not prevented from selling their own sexual services independently or cooperatively, including from fixed locations. A June 2021 Statistics Canada Jurostat entitled Crimes Related to the Sex Trade Before and After Legislative Changes in Canada indicates that since enactment of Bill C-36, those who are convicted or charged with the purchasing offense are almost invariably men. Profiteers and procurers are predominantly men, and victims are predominantly female. Both the Criminal Code and Statistics Canada refer to persons who are subjected to offenses as victims. In the 6 years prior to Bill C-36's enactment in 2014, 43% of those accused of sex trade-related offenses were women. In the 5 years after the change in legislation, 93% of individuals accused in all sex trade-related incidents were men, and 94% of victims in incidents where a sex trade-related offense were reported were female. Relevant case law indicates that the material benefit, procuring, and advertising offenses have been used in cases involving complainants who are predominantly female, under 18 or young adults, and vulnerable, for example, due to unstable housing or addictions. Those vulnerabilities are often exploited by procurers or profiteers who may exercise influence over them in a variety of ways, including by getting them to agree to provide commercial sexual services through psychological manipulation. Lower court decisions in the context of prosecutions have come to conflicting results on the constitutionality of the material benefit, procuring, and advertising offenses as they apply to the adult sex trade. the constitutionality of all the offences enacted by former Bill C-36 is currently before Ontario courts in the context of a civil application. Justice Canada also supports initiatives designed to assist those who have been harmed in the sex trade. I'll conclude here, and I look forward to attempting to answer any questions the committee may have. Thank you.
Thank you, Ms. Levman. And now we'll go to Mr. Moore for first round of questions, 6 minutes.
Thank you, Ms. Levman and Ms. Morency. Great to see both of you again. And I took from your testimony about the disproportionate impact that those charged with purchase and profiting are post-Bill C-36 have been men, and the victims are disproportionately women. You took us through how Bill C-36 was a response from Parliament to the Bedford decision. Can you expand a bit more on any information you have through the department on the effectiveness of Bill C-36? I know that's always an interesting point when we see government having to respond to a court decision. Bill C-36 was that response. So can you expand a bit on the effectiveness of this bill when it comes to going after those that are profiting from the sale of others' sexual services?
Thank you for the question. I'd like to make a few comments on the data that we have on the sex trade, and it does come from a range of different sources, including social sciences, criminal justice statistics, and of course, jurisprudence interpreting relevant offenses. The available social science evidence in Canada and internationally tells us about the groups that it studies. For example, Professor Benoit of the University of Victoria and Professor Bruckert of the University of Ottawa have studied practicing sex workers in particular locations. Their research that postdates Bill C-36 concludes that the purchasing offense makes screening client and negotiating safe transactions more difficult, and the material benefit and procuring offenses prevent sex workers from working together cooperatively and assisting each other. I would note, though, that the scope of the material benefit and procuring offences are currently before the courts, including the Ontario Court of Appeal in the NS matter, and that courts have made inconsistent findings on whether these offences criminalize sex worker cooperatives or sex workers assisting each other. So the parliamentary record for Bill C-36 indicates Parliament's intention wasn't to criminalize these measures. But obviously we have to wait now to hear about how the appellate courts interpret these offences, which of course has to be done prior to assessing them for charter compliance. So the studies that I've referred to.
Yeah, I don't have a ton of time, but thank you for that. Is the are there any cases currently before the courts where the federal government is intervening or planning to intervene to defend or support the law that's in place, the criminal code?
Yes, there is. There is, for sure. There's the Canadian Alliance for Sex Work Law Reform matter, and the Attorney General of Canada is responding to that. I didn't get to the next part of my data, if you'd like to hear about that, because the studies that I'd referred to focus on individuals who identify as sex workers. Others who have been involved in the sex trade may not identify that way, and those groups tend to be harder to reach. So we don't know as much about people who are coerced into providing sexual services or people who have exited. In my remarks, I noted the Juristat and the available jurisprudence indicate that the sex trade is a gendered practice and that profiteers and procurers take advantage of women and girls' vulnerabilities for their own gain. I can provide some highlights of the data reported in the Juristat, but I would note for the committee that, of course, Statistics Canada is better placed to provide detailed information on their own data.
How am I doing for time?
Would you like?
1 minute? Okay. So the advertisement online of sexual services is I mean, it's not an emerging issue anymore. It is an issue. And what, if anything, is the department doing to improve the law on that front? We hear from police departments and others that greater tools are needed to remove certain ads from the internet. Is there anything that the department's doing in that regard?
That's, I believe, an enforcement issue, and certainly we know from the jurisprudence, which I can speak to, that there are reported cases considering the advertising offense. It's most often charged alongside the material benefit and the procuring offense in cases where people are procuring or profiting from others' sexual services. The constitutionality of the provision is also before both the Ontario Court of Appeal and the Ontario Superior Court of Justice. And there is some data in the Juristat as well that the committee might find useful on the advertising offense.
Thank you, Mr. Moore. I'll now go to Madam Diab. You're off mute, but we can't hear you. Do you guys know? No, we still can't hear you, Ms. Diab. Now you're on mute, but before you were off, I don't think it's your mute button.
If you would like, Mr. Chair, I could ask some questions in
Sure.
giving Lena some time to, and she can take my position in the next round.
Mr. Batiste, go ahead.
Okay, I'm wondering if the experts can talk to me about. We did a study on this at the INAN committee that when we looked at Indigenous women within that are being exploited, and we were doing a study. I'm wondering if you could comment a bit on what are you hearing from sex worker-led organizations, community groups, in particular marginalized groups like the Indigenous women, and could you give us a little bit of understanding and elaborate on what's going on and what you're hearing?
Certainly. The research absolutely shows that due to colonization and intersecting factors of marginalization, Indigenous women and girls are disproportionately represented among those who are involved in the sex trade or who are trafficked for sexual exploitation. Now, individual groups, like different groups, representing Indigenous interests and individuals as well, have very different perspectives on the impact of the laws. So some advocate for decriminalization, while others strongly support the Nordic model on the basis that the sex trade is a product of colonization that has disproportionately negatively impacted Indigenous women and girls. And we do see from the data that is available a very, very disproportionate number of Indigenous women and girls involved in the sex trade generally, and that's from the data that's available both from the Missing and Murdered Indigenous Women and Girls report, as well as data from Dr. Bruckert and Dr. Benoit, their research.
Okay, I'm wondering if Ms. Morency, would you like to chime in on that as well? No, okay.
Thank you, I'm fine.
Okay, well, can I ask then, what changes do you think need to be made to be able to protect sex workers, and in particular, the marginalized sex workers from violence?
I can really only speak to you about the knowledge that we have right now, and certainly safety issues were front and center when Parliament was considering Bill C-36. Certainly Parliament back then acknowledged that some people choose to engage in sex work and that that's likely to continue to be the case, even in a regime that's designed to end the sex trade. So the record indicates that it's for this reason that the legislation doesn't prevent individuals from implementing certain safety measures, in particular those identified by the Supreme Court of Canada in its Bedford decision. So In particular, the parliamentary record indicates that the legislated exceptions to the material benefit offense mean that sellers of their own sexual services may interact with others on a personal or a commercial basis in the same way as anyone else, including if they want to rent particular locations or hire persons to provide services of fair market value. And the bill's immunity provision means that they will not be held criminally liable for providing sexual services independently and cooperatively, including by pooling resources to pay for services that are accepted by the material benefit offense. So acknowledging that these are live issues before the court, I would close my remarks there. Thank you.
Now, you mentioned two kind of polar opposite approaches to this. You mentioned the Nordic model and you mentioned what's currently. Is there any other types of systems that we should be looking at as the Canadian government? I'd hate to say best practices around sex work, but different practices that aren't just either legalizing it versus, keeping it the way it is. I just wondering if you could speak to any other countries that are doing any innovative approaches to laws on this.
Well, there are a range of different legal regimes that are applicable to the sex trade and have been implemented around the world. The prevailing debate, though, internationally concerns whether decriminalization or the Nordic model best addresses the risks associated with involvement in the sex trade. So you already know that decriminalization involves removal of all sex trade specific laws to enhance and protect sex workers' health and safety. So sex trade specific regulations may or may not apply in that context, but the critical feature of this model is that criminal laws don't. New Zealand is the usual example of decriminalization. The Nordic model, which is also referred to as abolition, the equality model, or the end demand model, seeks to reduce the demand for sexual services as much as possible with a view to ending the sex trade by criminalizing those who create the demand and those who capitalize on that demand, but not those who provide those services. And this is because this approach posits that the sex trade both reflects and perpetuates systemic and structural discrimination against women and girls. 8 countries have implemented the Nordic model to date: Sweden in 1999, Norway and Iceland in 2009, Canada in 2014, Northern Ireland in 2015, France in 2016, Republic of Ireland in 2017, and Israel in 2020. There are 2 other models, and I believe you referenced a couple of them. One is legalization. It involves a regulated sphere in which the sex trade is allowed to take place, with criminal laws applying outside that sphere. And Germany and the Netherlands are the usual examples of that model. And finally, there is prohibition, which criminalizes all of the involved parties, both those who purchase and those who provide sexual services, as well as anybody who involves themselves in anyone else's sexual services, including by profiting from them. So all the states in the US have implemented this approach, with the exception of Nevada, which has legalized brothels.
Okay. Thank you, Mr.
I think I'm just about out of time.
Yes, you are. Thank you. I'm going to go over to Madame Michaud. You have 6 minutes.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Thank you, ladies, for being here today. It's very appreciated. C36 had 3 objectives. You talked about them a bit: to protect sex workers who consider them as victims of sexual exploitation, protect communities, and reduce demand for sexual services. As far as you know, from the data you've collected since the bill was adopted, do you think these targets have been met? Can you give us a general picture?
Thank you for the question. I've already gone over the data, the available data for the committee for their information, but I'd be very happy to speak to the bill's objectives, which are of course articulated in its preamble as well as in the parliamentary record, which includes the Department of Justice's technical paper on Bill C-36 because it was tabled before both committees that studied that bill. The record indicates that the bill's ultimate objective is to reduce the demand for sexual services with a view to discouraging entry into it, deterring participation in it, and ultimately abolishing it to the greatest extent possible. The record also indicates that the Nordic model generally, and Bill C-36 in particular, is aimed at protecting the equality and dignity of women and girls because the model views the sex trade as disproportionately and negatively impacting this group, in particular the most vulnerable among them. The Nordic model also posits that the sex trade both reflects and perpetuates structural and systemic discrimination against women and girls. It also points to a range of harms, the parliamentary record I mean, that are perceived to be caused by the sex trade, and the legislation is aimed at addressing those harms, and they include harm to the individuals involved, in particular the most vulnerable who may not be sufficiently empowered to protect themselves, harm to women and girls generally by treating them as a commodity, and harm to all of society on the basis that societal inequalities negatively impact everyone. The record also indicates that the bill was intended to avoid the harms that some perceive to be caused by decriminalization and legalization, such as a larger sex trade and higher rates of human trafficking.
Je vous remercie et à la lumière.
Thank you. And with this information, in light of this information, I don't know, as part of your job, can you tell us if we've reached those objectives, or do more changes need to be brought to the criminal code? Does the law need to be updated because we did not meet those objectives? Can you tell us more about that?
Well, I tried to give an overview of the relevant data that speaks to all of this, including the Juristat from Statistics Canada and the jurisprudence. So we have numbers for charges under each offense that can be reviewed in the Juristat itself. I think that the Juristat could be very helpful to this committee in assessing the impact of Bill C-36. Does that assist? It's not my role to provide a personal opinion.
Je comprends, merci.
I understand. Thank you very much. I understand that some lower court decisions have been rendered. They said that it was difficult to protect the health and safety of sex workers. Do you have any recommendations to make about this? If, hypothetically, these parts are unconstitutional, how can we improve them? Can you give us some ideas about that?
Speak to the charter jurisprudence, if that could help.
Oui, allez-y.
Please go ahead.
Okay. So as I've said, the constitutionality of the sex trade offenses has been and remains before courts. Some of these offenses have been assessed for charter compliance at the trial level in the context of prosecutions, in particular the material benefit, the procuring, and the advertising offense have been considered with conflicting results. So we have at the Alberta Court of Appeal Klubikov case 2021, and that case struck down the material benefit and procuring offenses. And then NS, Ontario Superior Court of Justice, struck down all three provisions, and both decisions have been appealed, so they're before Alberta and Ontario appellate courts. Also, in three 2021 decisions that were subsequent to the NS decision, the Ontario Superior Court found the NS decision plainly wrong and refused to allow it. One of the main issues the court is grappling with is the scope of the material benefit and procuring offenses, in particular, whether they capture sex worker cooperatives or sex workers who help each other. So the parliamentary record, as I've said, indicates that these activities are not intended to be captured, but some decisions have found otherwise. So it's a live statutory interpretation issue that has to be resolved prior to assessing the provisions for charter compliance. So it's very difficult at this stage to answer your first question when we're not sure even what the courts will say about the scope of the offenses.
Thank you, Madam Michaud. I'll now go over to Mr. Garrison.
Thank you very much, Mr. Chair, and I thank the witnesses for being with us today. I think Mr. Moore and I are the only ones on the committee today who had the privilege of being in the previous Parliament that enacted this bill. And at the time, one of the few things I think there was unanimous agreement on was that there should be a comprehensive review of the Act and provisions 5 years after it came into force. And given that it was proclaimed in 2014, that meant that this review has been due to begin for the last 2 years. And so I'm not laying that on the government, I'm laying that on Parliament, that we are a bit late in starting this. But my first question has to do with whether the Department of Justice, in anticipation that this review was legislatively required, did its own research or commissioned research, because the review calls for a comprehensive review of both the provisions and the operation of the Act. So did Justice commission any studies itself, or are you simply depending on other studies that happen to have been done?
Thank you for that question. We did partner with Statistics Canada, their crime statistics division, to do the Jurostat. And there is a Jurostat that was done just prior to the enactment of C-36 for a comparison. And soon we will be releasing a report on the experiences and characteristics of those who were served by the organizations that received the funding that was attached to Bill C-36. We also, of course, always monitor jurisprudence and secondary sources, research, etc. That is normal part of our work, so that we can understand what's going on and how the bill is impacting others from the point of view of stakeholders.
And those who've followed the public positions I've taken on this will know that I was hopeful we could involve those most directly impacted by the law, and that is sex workers themselves, in the design and setting the scope of this study. So what you've just told me now confirms to me the importance of the testimony we're going to hear from those, because what we have is really just a review of case law and police charging statistics, and we don't really have from Justice the comprehensive review that would really need on this bill. Again, not casting that at you, I'm just saying that we don't have that available here. So I know the committee will keep this in mind as we continue to invite witnesses to the committee, that we really need to have a good balance that includes those who are most directly affected by the legislation. Ms. Levin, when you reviewed the objectives of C-36, the original bill, you reminded me of what my original objection was. The bill really comes from a prohibitionist stance. So its objectives are to stamp out, reduce, remove sex work. Those are laid out in the objectives as you described them. Would you agree with me that that is the premise that was behind C-36?
All Nordic approaches aim to end the sex trade. That is because they view the sex trade as a form of discrimination against women and girls, and a problem for their equality. So yes, that is one of the objectives, but I think Nordic model supporters would tell you that it's very different from a prohibitionist model in the sense that the Nordic model posits that there is a power imbalance between the person who purchases and the person who provides sexual services, and that power imbalance is recognized by not using the criminal law against people who provide their own sexual services. So in that sense, it's very different from a prohibitionist model.
And in terms of the Bedford decision that precipitated this action by Parliament, the Bedford decision was fairly sweeping in wiping out all the provisions that criminalized those involved in sex work. And so how would you say, and I'm asking for a legal opinion, not a personal opinion, but how would you say that the court cases now that are coming forward are dealing with the Bedford decision versus C-34? In other words, are any of those cases focused on whether C-34 and its current provisions are consistent with the Bedford decision?
Yes, well, as I've said, the case law comes to very different conclusions. We have conflicting results, and I've explained that already. But maybe I can note that during the study, as you'll likely recall, of Bill C-36, some parliamentarians did express their view that Parliament isn't precluded from imposing limits on where and how the sex trade may be conducted. That's from the Bedford case itself, in particular to protect the vulnerable and society from the harms that they view are associated with the sex trade. And these parliamentarians noted that the premise of any charter assessment has changed because Bill C-36's objectives are significantly different from those of the previous regime, and the bill would make the sex trade illegal. So Bedford was dealing with a regime in which the transaction for sexual services was legal. It was a legal activity, as the Supreme Court clarified. And parliamentarians also noted, those in favor of the bill, of course, that the bill attempts to balance the interests of those who choose sex work and are in a position to take steps to protect themselves with the interests of those who are not, by criminalizing purchasing and third-party involvement, while also ensuring that sex workers aren't prevented from taking certain steps to protect themselves, as identified by the Supreme Court of Canada in its Bedford decision.
Thank you, Mr. Garrison.
I know I'm out of time. Thank you.
We're out of time, and I want to thank Ms. Loveman and Ms. Morency for your time. We're now going to suspend, I guess, for a minute, or just for 1 minute while we get the next witnesses, but thank you for your time.
The opportunity for allowing me to speak. I would just like to start by saying that I'm coming as a private citizen, although it will likely be discovered that I am a police officer with 25 years, and most of my career has spent working with, I'll slow down, sorry for the interpreters, working with victims of vulnerable and gender-based violence in relation to sexual violence. I would like to come and speak concerning some of this stuff that I witnessed in regards to more specifically youth involved in human trafficking and procurement. So I could continue to speak, or I could just jump into questions.
It's up to you. You have 5 minutes, so if you want to make a statement for up to 5 minutes, but if not, then we can go over to Ms. Wesley, and then we'll go to questions afterwards.
I don't need to take any more time.
Okay, over to you, Ms. Wesley.
Yes, hi. So I'm Sandra Wesley. I'm the Executive Director of Stella L'Ami de Mamie, an organization by and for sex workers based in Montreal. I know Jen Clayman from the Canadian Alliance for Sex Work Law Reform was supposed to speak, and so I had prepared that she was going to maybe tell you guys more about the broad impacts of the law. So hopefully she will get a chance to come and do that. So what I will say is that, for one, it's really important to note that groups like Stella, we represent all people who exchange sexual services. No one comes to start and work in and lead an organization by and for sex workers if they haven't experienced violence, if they haven't experienced difficult working conditions, if they haven't lived the impacts of the law. So it's very important that you refuse this dichotomy of sex workers who choose sex work and maybe have happy experiences, and sex workers who experience violence, who have bad working conditions. We organize to fight for our rights because things are wrong and we need to fix them. So I think that's a very important point that I urge you to resist. Just because we do not give you horror stories, just because we do not share those intimate things with you, does not mean that those things do not exist and that that's not who we're speaking about. So I think the first thing I want to say is that the entire PCEPA needs to absolutely be repealed. It is a law that is dangerous, that is harming people in many different ways, and there's no middle ground. There's no repealing some of it or tweaking it to make it acceptable. It is a law that harms people, that puts people at risk of violence, that encourages exploitation in the sex industry, and that prevents us from having good working conditions. I also want to point out that there's not a lot of debate about the harms of this law. What we just heard from Ms. Levman is that, as she said, the new objectives have changed the analysis of this of the constitutionality of this law, which is very similar to pre-Bedford laws in some ways. What that means in day-to-day terms is that no one is necessarily disputing that this law is killing people, that it is putting people at risk of violence, that it is putting people in poverty, that it is doing all kinds of harms to people. It's just that now, with this bigger objective of eradicating us, then maybe some people think there's an argument to defend that it's okay if some of us get murdered in the pursuit of that objective. So I just want that to be very clear. So I'm going to list for you a few examples of situations that we see as we provide services to sex workers in Montreal. We provide services, we make about 5,000 to 8,000 contacts per year with sex workers here in Montreal. So since the law has passed, sex workers can now be evicted from their homes if they work from home. We have many decisions in Quebec where the rental board has evicted people based on the fact that they now do criminal activity in their apartments, and therefore that is grounds for eviction. This puts women at risk not only of the actual eviction, but also of threats and extortion from their landlords, who, when they discover that they have this power now to evict them, may double the rent, may demand sexual services in exchange for money, may threaten them in many other way. We see this every day here at Stella. Then in terms of employment, what it means is that because sex work is criminalized and our income is product of crime, we do not have access to employment insurance. At the beginning of COVID, we didn't have access to CERB and to the new assistance that is available now. We do not have parental leave. We cannot have any recourse with employment standards or with occupational health and safety institutions. All the protections that belong to all workers across Canada are not accessible to sex workers. This has very dire consequences on women that we see here every day. In terms of money, it is very dangerous now for sex workers to use bank accounts or any sort of banking instruments. Platforms such as PayPal and other online payments will track down sex workers and shut down our accounts because of the criminal activity. FinTrack has been mandated to monitor transactions to spot sex workers under the guise that we might be victims of trafficking. So banks are now tasked with spotting sex workers and reporting us, seizing our money, freezing our money. We see sex workers come in here all the time telling us, my bank just froze my account because they said my phone number is associated with my escort ad and I looked like a sex worker and they investigated me. The consequences of that are really dire. Same thing for simply things like reporting income tax. Our income is criminal, so what do? Do we file a tax return with our income and risk consequences? Do we not do it? Sex workers have to face these decisions every day. Then in terms of violence, obviously these laws greatly increase the risk of violence. For one, we cannot report violence without any violence against us being reinterpreted through the lens of sex work being the violence as opposed to the actual crime that we want to report. One example could be a sex worker who's receiving threats or being harassed by a former boss. This person will come here at Stella, we'll sit in our living room with her and go through her options, and she will figure out that if she goes to police to report harassment, there's a very high likelihood that she will have to disclose the relationship with this person, and that police will then investigate her former workplace. Her former colleagues might be deported, might be arrested, the receptionist might be arrested, the workplace might be shut down. And police will focus on the fact that she's a sex worker and not actually address the harassment. Same thing if there's an assault by a client in a workplace. We have a very dire example in Quebec City of a young sex worker who was murdered by a client who had been banned from a massage parlor. That massage parlor was not able to report that to police. And then when she met with him at a hotel, she could not put security measures in place because her objective had to be to protect herself from being detected. Because she was participating in crime in that moment. We have another example of a Montreal sex worker who was murdered in Alberta. She was working with an agency, and when things seemed to not be going okay, the driver was not in a position to be able to call the police to ask for help because as a driver, he was committing several of the offenses of the PCEPA. And it took 3 days to convince police to go and actually look in that apartment and find her because sex work is criminalized. For street-based sex workers, especially Indigenous women, it's very clear to us that all
Ms.
women
Wesley, I'm just
who
going
are
to ask you
most...
to wrap up, but because then we'll take questions. Go ahead.
Okay, I'll just finish this one point. So all women who are the most at risk of police repression, of unwanted contact with police, are the women who are the most at risk of going missing, of being murdered. We have examples here in Montreal of sex workers who have gone missing, who have been murdered, who are still missing today because of this constant race to escape from police. It is the same women who face the consequences of this law who are the most at risk of violence, and this law plays a huge role in this. It is not the only factor, but it is a major factor. So,
Thank you.
Okay.
Yeah, sorry. Thank you, Ms. Wesley. I will go to our first round of questions, and we'll start with Mr. Morrison.
Thank you, Chair. My questions I'm going to focus on are for Ms. Botting. With your experience frontline policing in Ottawa or in Canada, just curious about a few things, and I really want for this committee to understand what it's like on the streets, I guess is what the reason I'm glad you're here as a witness for us. You were involved in a really interesting investigation a few years ago, and I do remember talking to you about that many years ago, and that's a teen pimping operation with young girls. I just wonder if you can just explain to the committee here, you know, how did these young girls manage to control the sex workers, and you know, and I guess after that, just tell us what you as a police officer or as a person learned from that investigation.
Thanks for the question. I just wanted to touch on what Ms. Wesley said and how passionate she is, and the safety of the people that are involved in this has to be paramount. What I have observed throughout my career is the vulnerability of recruiters, and that the women and girls that are involved in this often become recruiters as a result of the abuse that they've gone through. And I agree with Ms. Wesley that many people don't get into this, the dichotomy of the glorified working sex trade work versus the horrors that's most of them face. And the girls that I've met and the girls that I work with, they become recruiters because if they're recruiting, then they're not subjected to the same level of violence. They're now recruiters. And I noticed, in this law, there is a punishment for recruiters, but our laws are such that it is very difficult to prosecute a recruiter who is the middle person, who is also a victim. And so the girls that pimped out the young girls in Ottawa, and then that evades the actual pimp. The pimp evades the prosecution if we're going after recruiters. So the recruiters are the ones that look like they're the pimps. These teenage girls, we were never able to find out who was above them. And I have no doubt in my mind that they were involved in prostitution. So how did they control these girls? They're young girls. They're the same age. We have to find a way to protect young girls from recruiting other young girls. They were the exact same age. They went to a party. They forcibly confined them. They drugged them, and then they turned them out onto the street. The other cases that I've been involved in, the pimp had young girls at the same age, 15, 16, 13 years old, bringing them to parties, bringing them to hotel rooms, vulnerable victims from areas where we have to question ourselves, where are they running from and what are they running to? So in Mr. Morrison's question, what would some of those solutions be? Like, we need the one, how do we prosecute a person who is procuring when the bigger issue is why are they procuring and where is that money going? And how do we recognize that that person procuring may also be a victim? So I did have a case where we prosecuted the procurer. She was a 16-year-old girl at the time. We put her through the youth criminal justice system, and she testified at the pimp's trial as well. And we always viewed that girl as a victim. She was sentenced to 2 years. What that did for that girl was get her away from everybody that she was associated with. And that in itself, she got her high school diploma, she got her college education in those 2 years, and then she's now out in society, married with children, and actually somebody that I contact every now and then. So I don't know if that answered your question perfectly, Mr. Morrison, but the solution, some of the solution would be to have social workers in the school recognize, deal with high-risk missing youth, recognize the signs. The girls that I know and I've become friends with through working with them all have this, I've learned from their stories, and they've passed this along.
Thank you. I just wondered too if you can just tell us, the committee here, what tools do you see that you could add to policing that would actually have a real impact on the sex trade?
The one tool that was recently taken away from us that had a big impact when I was working was the school resource officers. When you are in a high school and getting to know the youth involved, and they're getting to understand that you do have their best interests in heart, that you are a person in the community that they can go to. That's where I began recognizing the vulnerable victims that could be involved or could be recruited. And then you're able to access those resources. You're able to work with the school sometimes the Children's Aid Society, there's recruiting going on right inside their own group homes. The school resource officer and the guidance counselors are right there working day in, day out with these vulnerable victims in the high school system.
Thank you.
That's one tool. That's one tool that's been taken away from us in our own city.
Thank you, Ms. Botting. I'll now go to Madam Diab for 6 minutes.
Okay, thank you very much. You can hear me now, can you?
Yes, I
Yes,
can.
we can.
Okay, très bien, merci. Okay, Miss Wesley, I listened intently, and I heard your passion. Just a few questions. How long have you been doing this? And you were speaking, definitively saying that this legislation needs to be, I guess, gotten rid of because it's not working. And in fact, it is working in the opposite direction that it was intended to when it was implemented in 2014. You also talked about working conditions, protection for workers, a number of areas where the largely women and girls are treated or not treated according to the law the way other people are treated. And can you please share with us a bit more based on your experience of how long you've been working with this exactly? What is it you would like us to see? As you know, we're meeting today to understand, is this act working? Is it not working? Should we make amendments? If so, what kind of amendments? Can you tell me a little bit more about your perspective?
So I think that, whether or not it's working is a difficult question because the objective of the law, when the main objective of the law is an objective that we obviously highly disagree with. So one of the objectives of this law is to send a strong message that as Canadians, we have a social project to eradicate sex workers, that we hate sex workers so much that we want to make sure that there is not a single sex worker left in this country at the end of this repressive regime. And so obviously every single aggressor, every violent man, every exploiter out there hears the same message that the government of Canada wants to eradicate sex workers. And there are plenty of cases of aggressors who don't feel that they're committing anything particularly bad when they're being violent towards sex workers because they're doing what the government is also wanting to do, which is to eradicate sex workers. We have the example in the United States of last year where a man went and shot a lot of sex workers in massage parlors. He felt that he was following guidance from his community, which said you have to eradicate this industry. So for me, whether or not this bill is working, it's more whether or not it is impacting people negatively. When we analyze things from a human rights perspective, the main question we first have to get out of the way is, are people being harmed by this law? And this is an unquestioned yes. People are absolutely being harmed by this law. And then the second question is it worth harming them? And for us, as the people who are suffering the consequences of this law, it's obviously not worth it. And I want to add that it's very important to separate sex work from violence towards sex workers. We have a criminal code that is full of other laws of general application that should apply when people experience violence, whether at work or elsewhere. It is illegal to kidnap someone. It is illegal to rape someone. It is illegal to drug someone and make them do things. Those things are already crimes. We do not need sex work specific laws that say, no, the sex work itself is the violence in order to prevent those things. And so what we're seeing, and obviously I think it's important when we're talking about violence, not to think that all sex work is all violence all the time, or that the majority of sex workers are just experiencing violence on a daily basis, because that's not the case. But we know that we're experiencing violence, we're experiencing barriers to accessing care, we're experiencing health risk from this. In the context of a global pandemic, we should be really concerned about health and about the knowledge of public health experts. And I hope that you will hear from some public health experts who will tell you that decriminalizing sex work is one of the main objectives in the fight against HIV, that we will never end the HIV epidemic if we don't decriminalize sex work. UNAIDS has one of their objectives for 90% of countries to have decriminalized sex work by 2025. So Canada, by choosing to ignore this and to aggressively criminalize sex work, is choosing also to not be a global partner in the fight against HIV.
So Ms. Wesley, can I ask you another question? We heard from previous speaker before this panel about statistics on those that are working in the industry, those are that facing charges, etc. From your experience, can you speak to us, to what you see through your work? Who is working in the sex work? Who are the clients? Who's the most vulnerable or at risk of violence? And what is the misinformation that you hear on sex workers in the legal system? I think you started to talk about that.
Yes, so I think it's very important to first point out that the data regarding the justice system is obviously very incomplete, because most sex workers are not in those files. And obviously when we are caught up in a criminal investigation, we will not disclose facts about ourselves if we don't have to. So that data is very limited. What we see at Stella in the context that we make is that sex workers are incredibly diverse. We have women of all ages. It is completely false to think that most sex workers are young. At Stella, the majority of the women that we see are in their 30s. We see a lot of women obviously in their 20s and their 40s. We see women in their 50s, 60s, and much older as well, that have been working in the sex industry for a long time or that are starting to work in the sex industry. We see a large proportion of trans women, of non-binary people. We don't serve men, but we know that they're also very present in the sex industry. They're not seen in the statistics so much because there isn't a big social project to see men as victims of sexual exploitation and to eradicate them. So there's not so much police enforcement that directly targets men. So we don't see them maybe as much in the stats, but they do exist in our community.
Thank you.
Indigenous women.
Ms. Wesley, we're just going to have to go to the next question. Sorry. Thank you, Madam Diab. Madam Michaud.
Merci, mesdames.
Thank you for being here. I was trying to get an understanding of the situation from the representatives of the Department of Justice, and it was difficult for them to express a personal opinion, which is understandable, but I'm hoping that we will be able to get more out of you. What do you think about the general situation on the ground since Bill C-36 was adopted? Do you think that the three objectives that were set out by this law were reached, and what would the negative consequences be? I've heard you talk about the negative consequences, so maybe you can elaborate on those that are connected to the bill.
Sure.
Yes, of course. So in terms of protection, and I think that we have to note that protection isn't the main objective. We can't eradicate and protect at the same time. There's a contradiction in these two objectives. But what we say is that by criminalizing sex work, it complicates all aspects of the sector. So if a woman is working on the street, she is already criminalized. She can be arrested if she gets close to a park or a school or a daycare, which is anywhere in a city. Also, if she's blocking traffic as part of her work. Also, her client will be criminalized. So what that means is that maybe before the bill, if a client was speaking to her, or if she was talking to a client, looking into the car, seeing if it was safe, negotiating a price, negotiating the use of condoms, negotiating a space, and then she can get in the car and go off with the client and feel safer. Now, the client is not going to stay at the curb for 5 minutes to talk with a sex worker before getting in, because they'll get arrested for simply having this conversation. Talking about using a condom is a crime. So we're going to jump into the car very quickly and then become at the mercy of the man who's driving the car, can take the person anywhere he wants, can change the agreed upon rate, can go back on what acts were agreed upon. They can, for example, if they had agreed to go to Hochelaga, she could end up being on the South Shore. What's she going to do? Jump out of a moving car? So the sex worker is in a very dangerous situation. What about women who are working online? They can place ads on websites. The websites are constantly being shut down. They have to figure out how to fund their ads, use cryptocurrencies, or maybe ask other people to help them. And they take risks by doing this. And then with the clients, if they try to communicate with the sex workers, they're committing a crime. So clients won't want to give their real name. They won't want to negotiate the transaction in detail. They'll use coded language. And then it's once they've made an appointment and that they're face-to-face with the sex worker that they'll do the negotiation. And this just all creates a situation that is fertile for violence. There are so many exceptions, but in the facts, when you come down to it, anyone who helps you is committing a crime, and then they have to hide from the police. So what this does is it eliminates all possibilities of good working conditions. It actually encourages people with worse practices to enter this industry because workers that have good working conditions don't want to be involved in a crime. So here we're fostering an environment that can promote crime and violence. Third parties can be colleagues, for example, our driver, our boss, our receptionist. They could also be sex workers, but these people could also be our spouses. They can be considered a procurer and not a spouse. So then if there's domestic violence, the sex worker finds herself with no resources. So the spouse can threaten the sex worker. They could threaten them to take away their children. They could call child protective services. We meet so many women that are constantly terrorized by current and past partners that are making threats against them. They know that if these people are in front of family court and that the spouse says that they're a sex worker, that they're committing crimes, they will lose custody of their children. We also have to empower social workers to address real issues in the family to help children stay at home. But instead, families have to hide behind, social workers have to hide behind their professional orders by saying that they can't help people that are committing crimes. So it prevents sex workers from having access to social workers as well. I could go on. We could talk about ads that have had a devastating effect on the industry when they were criminalized. Before, women could place ads in the Journal de Montréal, for example. It was very easy. It was a short text. It wasn't very expensive. People could go in person to pay with cash. Newspapers had to stop publishing these ads because now it's a crime, and now women have to post ads online. The women don't necessarily have a smartphone, don't necessarily have the internet or a credit card to pay for these ads. So now there are expectations also of having more photos, more communication with clients. So you can imagine that these women are terrorized, especially the women who are older, that are in their 50s, that need to learn how to make money. They lost their revenue from one day to the next. And now they're greatly endangered.
Leslie. Mr. Garrison.
Thank you very much, Mr. Chair. And I want to start by thanking Ms. Wesley for her important testimony here today, but also by thanking Stella for the important work it does in the community and working with sex workers. I was trying to pick out what I thought was the most important thing you said, and you said so many important things I'm having a little trouble. But I want to focus on one thing that you did say, and I'm going to paraphrase you here. You said defining sex work as the violence prevents reporting the actual violence. And I think the parallel, though, is defining sex work as exploitation also prevents reporting real exploitation. And could you give us some examples of how that works in real life with the law as it exists?
Yes, absolutely. So when it comes to work exploitation, the concept of exploitation in a workplace context is not something that usually belongs in the criminal code. It's something that belongs in employment standards, where we have as a society given ourselves recourses in case of bad working conditions. So sex workers don't have access to this. If our boss refuses to pay us, well, there's no tribunal we can go to for that. If our workplace is unsafe, there's no Occupational Health and Safety Commission that can come in and help us with that problem. And so a lot of workplace exploitation comes simply from the fact that we don't have access to those things. In every other industry, when workers have faced exploitation, be it workers in any industry, we've focused on giving workers rights as a way to end exploitation. When we criminalize an industry, what we're doing is that we're making exploitation as the default setting in that industry because the worker is not protected. So we're talking about power dynamics. A lot of people mention the power dynamics between sex workers and other people around us. Those power dynamics exist because we don't have legitimacy, we don't have rights, we can't turn to anyone. So the only thing that exists that we could in theory turn to are criminal laws. And those criminal laws, what they say is not that there's a difference between a good boss and a bad boss, that there's a difference between a good coworker and a bad coworker. What it says is that all of it is inherently exploitative and inherently wrong. So what this means is that if someone works in, say, an escort agency and everything is great, well, her colleagues are committing exactly the same crime as a boss who's beating the employees, taking all their money and doing all kinds of other things. And what it means when we go to police is that you'll see, if you look at the data in terms of charges that are given to people, very frequently the only charge given is a procuring or material benefit or advertising charge. And if those charges don't need to prove exploitation, violence, or anything bad happening, then what are we prosecuting exactly? The best co-worker in the sex industry is committing the same crime as the worst one. So that's obviously illogical and incentivizes people to exploit us. Then obviously there's all of the other types of exploitation in our personal lives. What sex workers experience and what is often portrayed, sometimes there's graphics that are put out about, pimps and exploiting their partners at home. And it's the exact same pattern as any domestic violence situation. In domestic violence, abusers take control of family finances. That's a feature of domestic violence that is the same whether someone is a nurse, a sex worker, or any other job. In a situation of domestic violence, the person will threaten and force maybe the person to work more than they want to work and do all these other things. And those are not different for sex workers. What is different, however, is that we have a law that doesn't even allow for domestic violence to be part of the conversation because our partners are not even seen as our partners. The law goes as far as trying to establish what would even constitute legitimate cohabitation with a sex worker. And so when we go to police, instead of being directed towards domestic violence services, we get directed towards anti-sex work services that will tell us that we need to stop doing sex work and that will try to convince us that we're actually victims of sex work and not of violence. And beyond the criminal law, this also is what we see in community services. The vast majority of domestic violence shelters across Canada operate from an anti-sex work prohibitionist perspective and will not allow someone who's currently working in the sex industry to access services. So we see countless women at Stella who are trying to escape violence and end up in a situation where if they go to police, the sex work will be investigated and they do not want that. They cannot go to a shelter because they're not welcome there. And they have to find solutions on their own to get out of that situation. So obviously, if someone wants to exploit the labor of someone else, they will pick someone whose labor is available for exploitation, and anyone who's criminalized will be a good target. That's why we see also exploitation of undocumented migrants. Anyone in our society who doesn't have legitimacy, who doesn't have access to services, who doesn't have access to human rights will be the target of people who want to abuse people. And we think that there are many other laws in the criminal code that address many types of violence. And I also want to bring up, because earlier someone mentioned human trafficking. Human trafficking is not, as far as I understand within the scope of this study. And there's this tendency to conflate trafficking and sex work, to use them interchangeably, or to otherwise act as if all sex work is trafficking. And I think it's very important to not get caught up in conversations about trafficking. If we decriminalize sex work, if we repeal the provisions of the PCEPA, the human trafficking provisions at that point would still stand. And if something meets that threshold, those laws still do exist. They're used very problematically in our communities, but at the end of the day, they still exist. So we do not need to criminalize sex work in order to criminalize something that we would consider to be trafficking.
Thank you.
Thank you very much.
Thank you, Mr. Garrison. I'll now go to Mr. Brock for 5 minutes.
Thank you, Mr. Chair. And I'd like to thank both Ms. Botting and Ms. Wesley for your presence today and your very helpful responses to a number of questions by my colleagues. Prior to becoming an elected member of Parliament, I enjoyed a 30-year legal career, the last 18 of which I was a Crown Attorney in Ontario, and had extensive experience dealing with the prosecution of human traffickers and other exploited victims. So this particular area is near and dear to my heart. I'd like to, with time permitting, address both of you ladies. I'd like to start with Ms. Botting. Ms. Botting, we've heard, and I think you've had the opportunity, have you had the opportunity of listening to the testimony of Ms. Wesley?
Yes.
Yes, thank you. Ms. Wesley, amongst other things, pitches and makes the strong argument that Bill C-36 and the legislation that was adopted is actually more harmful to the sex workers than actually the stated objectives. I have information before me from the Library of Parliament that would suggest that there might be a disconnect in that particular statement, and I'd like to hear your thoughts on that. Statistics Canada in 2021 published that crimes related to the sex trade found a decrease in reported injuries and homicides of sex trade workers after Bill C-36. Would you agree, with your background in policing, would you agree that the changes made by that bill have made individuals who sell sex for money safer? Please explain why or why not.
Well, I'm certainly no expert on the statistics, and I don't have any data to support what you have said. And I am also love Miss Wesley's passion for the work that she does. My understanding of Bill C-36 is that sex trade workers are not charged under this law. So we do not target the sex, at least in my city. We do not target the sex the way Miss Wesley suggests, and we don't target the sex trade workers, and we have not for years. We are targeting the abusers that are involved with the most vulnerable, and very often that's youth. So my question, if I may ask, would be, how does Miss Wesley suggest we protect the youth that are involved if we don't have laws against those that procure them when they haven't met the threshold of human trafficking? And the other thing that we do in our city is we work with the victims or with the sex trade workers if they want to work with us in providing them safe resources. And we do not force them to testify the way we historically did many, many years ago. I began working in this field in around 2003. Began working on the prosecution side. I believe my first was 2005, 2007. And we do not have the practice of forcing those involved in the sex trade industry to, one, cooperate with us, and two, to testify. My biggest concern with repealing this law completely would be how do we protect people when they don't fall within the laws of human trafficking or sexual assaults or assault, but they're simply being recruited and there's no law to protect from that. So if a girl or a boy came to their school resource officer and said, hey, this girl in my group home or this girl in my school is really attempting to get me involved and I need help, where's the law that applies to that situation and how do we prevent it? That would be how I would respond to that question.
And I thank you for that, and that is consistent with my interpretation that each jurisdiction has a different focus in terms of how they apply the law. So it should become as no surprise that provincial objectives and provincial statistics probably differ as well. So taking that one step further again and contrasting Ms. Wesley's statement and her testimony so far, she also says it would be an error to conflate Bill C-36 with human trafficking. And I think to an extent you probably would agree with me that it's not really conflating the two issues. The two issues are really hand in hand, at least from a prosecutorial standpoint. I've had numerous instances where victims of human trafficking, once they went through that ordeal, ultimately decided to continue on in selling sexual services on their own after they freed themselves from their abuser.
Unfortunately, Mr. Brock, we're out of time, but I'll let Ms. Botting do a brief answer. A brief answer, Ms. Botting, if you could.
Yeah, I do agree that they are similar, but they're not the same. And I had a train of thought and I lost it. Sometimes they go hand in hand. I'll just reiterate, my biggest concern is where is the protectionary law? Bill C-36 is a protectionary law. Human trafficking is the trafficking side, and they're not always one and the same thing.
Thank you, Ms. Botting. Ms. Dillon, over to you for 5 minutes.
Demander, en pratique, comment fonctionnerait...
The microphone is not on.
Que pourrait faire... Oui? Oh.
Madam Dillon, if you can put the microphone, and I'll start you again as there was no translation services.
Merci, Monsieur le Président. Alors...
Thank you, Mr. Chair. Madam Wasi, how would decriminalization work, and how can the government make sure that sex workers benefit from adequate protection if we decriminalized their means of generating revenue? What are the advantages of decriminalization compared to legalization? Thank you. Thank you. For us, decriminalizing is essential compared to legalization. Legalization would create a very restrictive framework for sex work and will criminalize anyone who doesn't fit within that small box. Our objective is to protect the women who are the most marginalized in our communities, so people who are working in informal areas who will not be able to comply to complex regulations, get permits, etc. So legalization would remove, decriminalization would take away the criminal element, but then would grant them all of the protections that other workers have, like occupational health and safety, EI, etc. There are 25 groups that are working together and have done an extensive consultation over 18 months with groups that work for sex workers. This document that will be submitted to you outlines what would happen federally and what questions provincial jurisdictions should be looking into, for example, health and safety. And so the response is cohesive, and the solution is often to remove specific regulations that apply to sex workers. There's also rules about immigrations that have to be removed, because anyone who is not a permanent resident that is a sex worker is automatically deported. So we would eliminate those things. I'd also like to come back on talk about what we were talking about earlier with police repression. I have concrete examples, and these would not be possible if we decriminalize sex work. For example, there's a Radar, a program in Montreal where hotels and taxis need to identify sex workers and report them to the police. So they're basically terrorizing sex workers who can't use hotels safely anymore. There are also police operations where many police officers, 10, 20, 30, will go onto a work site and detain all of the women, ask for ID, and look them up. In 2009, there was one operation that was particularly violent. It noted all tattoos and piercings on the bodies of these sex workers, and they said to these women that now we'll be able to identify your bodies when we find them. And this is all a fear tactic of the police against sex workers. And you can imagine the impact that this type of interaction with the state can have on a sex worker. So these are tangible examples. Even if we talk about, even without an arrest, it creates a climate of fear. It has extreme consequences, and it's an extreme violation of human rights. So by decriminalizing sex work, you take that power away from the police. They can no longer harass sex workers, invade their workspaces. And then let's also talk about protection. There's a whole other portfolio of measures in the criminal code that talk about violence. There are many feminist critics of the criminal code that say that it doesn't respond to violence against women, and we need reform. Sex workers want to be included in this work and don't want to have specific laws that come and ban sex work. We can't prohibit and protect together. We have to choose what is more important. Does that answer your question? Yes. Quickly, do marginalized people face more dangerous situations? What can we do to help them more? The most marginalized women are the ones who experience the direst consequences. They are the ones that are represented in prison, that have difficult relationships with the state. 80% of incarcerated women in Quebec are sex workers. This includes many Indigenous women, migrant women, trans women. These are targeted by police and by aggressors. These groups target victims, and this is the position we take when we're asking to decriminalize sex work. We're not saying that some women love this work and they want to do this work and they need to be decriminalized. What we're saying is that decriminalization removes the impact on the most vulnerable women, the women that are experiencing homelessness, who are experiencing substance abuse, that are Indigenous, etc.
Very impassioned. Next, for 2.5 minutes, Ms. Michaud.
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'll come back to you, Mrs. Wesley. You mentioned the case of Marilyn Lévesque earlier. Last year, I was on the Public Safety Committee, and we studied this case. I think you were testifying then. You talked about violence against sex workers, that police focus on this, and that's why women hesitate to complain or press charges. Is there a solution to this? Should we change the law? Should we change the mentality in law enforcement and their perception of sex workers. What do you think about this in 2 minutes? The first step absolutely has to be decriminalization. In a context where police officers have a mandate to eradicate the sex industry, they've been told by the parliament that all sex work is exploitation. There's no space for positive relationships in such a context. Once decriminalization is achieved, we can develop more positive relationships with law enforcement. Here we can make a distinction between violence and what's not violence, what's a crime and what is something else. For the time being, it's not possible. We can't ask a police officer to apply the law according to his own judgment. Of course, police officers are not arresting all sex workers, all clients, all third parties. This would be extreme. It would require so many resources, but we can't have a law that allows them to arrest all these people and then decide when or not to apply it. We have to remove this mandate. We also can't ignore the fact that the relationship between marginalized populations like trans and Indigenous people and the police are toxic relationships. Indigenous women are 12 times more likely to be accosted by the police than white women.
Every time I bring up Indigenous women, you cut me off.
Oh, what I'll do is, why don't you? Would you like her to? I'll let you finish that off first, Ms. Wesley. I don't want to cut you off.
That would be nice.
Sure.
Yes. So I've been cut off every time I've been trying to get to Indigenous women, and I think it's just very important to really acknowledge that Indigenous women make up a huge percentage of the women that we reach at Stella. They are the women that we see the most in prison. They are the women that we see dying at the fastest rates. We are constantly having vigils for women who had preventable illnesses that they died from because they couldn't access healthcare. We have been in situations where one of our outreach workers on the street has called 911 for an ambulance for someone who was having a health emergency. And the 911 operator asked, well, is it an Indigenous woman? And they sent the police instead. We have women that are currently missing. We have women that have committed suicide since this law has been put in place. We have women who have been subject to incredible violence. And I think it's very important that we ask ourselves, why is it that as a society we're starting to accept that the criminal justice system is colonial, is racist, is violent towards Indigenous people, and is part of a genocidal project against Indigenous women, but somehow think that when it comes to sex work, it's different, and all of a sudden this system is helpful. It is not helpful for Indigenous women. We need all kinds of other things that are not criminal. We need people that are not police officers in the lives of Indigenous women, and we need to stop this unwanted contact with police, this hostility from the system. So I just really want you to consider that if we actually have a commitment as a country to end the genocide of Indigenous women, then we need to have a commitment to making sure that no Indigenous woman is targeted by police, either as a criminal or as a potential victim on the basis of the fact that she is selling sex to make money. If we are outraged that we have people in our society who are in desperate poverty, who need to do anything they can do to survive, then we need to act on the poverty, we need to act on the exclusion, we need to act on those things. We do not need to criminalize poverty, to criminalize being Indigenous in a city away from your community. Those things should not be crimes. And this law is a way to criminalize being an Indigenous woman, especially in an urban setting. And that really, if there's one takeaway from this testimony, it is possible to be committed to ending violence against Indigenous women, and it's possible to have a critical analysis of how Indigenous women start or continue to sell sex and to support decriminalization. Those things are coherent and they all come together as one package.
Thank you, Ms. Wesley. I just wanted to say I did not want to cut you off at the Indigenous part. I just have to manage everyone's time, and it's a difficult task on my side, but thank you for clarifying that up. Over to you for the last 2.5 minutes, Mr. Garrison.
Thank you very much, Mr. Chair. I want to turn to a question that Mr. Brock posed and said he was going to have you answer, and then, of course, ran out of time. And that's the question about whether the statistics show an improvement after this law was brought in. Because it seems to me that it's equally likely that the statistics show a drop in reporting rather than an actual improvement in conditions. And I'd like to know if that's your view of the situation.
Yes, absolutely. And I had a chance to review in great detail the report that we've been talking about, the statistics. And it's very clear to me looking at those statistics that it reflects our reality of what we see, that there's actually a decrease in sex workers reporting violence, and also a decrease in how sex workers might be counted in statistics, because even those who report violence will go to great lengths to avoid being captured in those statistics. And obviously there's a lot of problems with those statistics, including the lack of understanding and representation of trans women. So I think that what those statistics actually show is that people are not reporting and that people are not having any sort of improvement of their relationships with police. The idea that violence has decreased because of this law is absurd. And the same people who will tell you that, who will rely on those statistics to argue this, will be the people who will come and then tell you that they need more of hundreds of millions of dollars to fight against this violence that they say is increasing every moment. The reality is that we're the ones actually working every day. We're the sex workers, we're in the industry. There has been no reduction in violence because of this law. There has been an increase in many types of violence. There are no sex workers in our community who feel that criminalization of their actual work and not of the violence is a useful tool in order to protect them.
Ask you one last question. What would you hope to see come out of these hearings, this study we're doing?
So we don't have a lot of confidence in this process because it's not conducive to actually looking at evidence and data. You know, just from my brief testimony here, I've been told that I'm passionate about 5 times, which is code to say, you know, okay, we get it. You're like an angry sex worker with emotions, and it's a way to dismiss what I'm saying as if it's not evidence, but opinion or feelings. We have thousands of pages of evidence, and we will submit evidence to you. And I expect every one of you who has our lives in your hands, who stand between us and the ability to maybe work without being murdered, to maybe raise our children without interference from the state, to actually read every page of that evidence that we send you, and to come to the conclusion that the only reasonable thing to do at this point is to decriminalize sex work. It is inevitable. It will happen at one point, and we will look back at this time in our country where we decided, instead of encouraging sex workers who had a win at the Supreme Court, we decided to ignore the Supreme Court and punish them for fighting for their rights. We will look back on this as one of the moments in all of the world's history where a Supreme Court human rights decision was blatantly ignored by a government. And you have the power right now to recommend to repeal this law and to right the wrongs of this law. One of the slogans that a lot of sex workers use is only rights can stop the wrongs. So we're hoping that what will emerge from this is a clear recommendation for human rights, not that there are people who disagree, not that there are more research needed. The research has been done. It is published. And it doesn't matter how many people come and tell you that they don't like sex work, that they think it's wrong, that they think it's exploitation. Are people harmed by this law? The answer is yes. We have a duty. We have a charter. And it's outrageous that in 2022, we're still here arguing for this very basic principle and pretending that it's not entirely a moral and ideological argument.
Thank you, Ms. Wesley. And I would just want to say you're actually I've been not a chair for long, but I've been a member of many committees, and you're very articulate and you're very clear and precise and to the point. And I want to thank both you and Ms. Botting for appearing today. And I will guarantee and assure you that your views will be taken into this report and action forthwith. I will now thank you, and you can be dismissed. I just have a quick thing while you guys can stay on or log off, it doesn't matter, but I think just approval of the budget, if I can have the members' consent to move to approve the budget. Yes, all in favor? Okay. That's it. I will suspend and thank you once again, and we'll see you on Friday. Adjourned.